documents volume 2. Just it's the index, Mullahs, really. Right. Right.
So you referring to preamble at page 16?
Yes, but before that, Mullahs, just so that you know Mullahs, what the Constitution was dealing with.
Page 5 is part 3, you are saying.
Page 5.
You're wanting us to read page 5?
Contents, Mullahs. Contents. The state, permanent residence, directive principle,
Yes,
state policy.
Yes.
PDF 5.
Yes.
Just the contents, Mullahs. Yes. You see now. Part 1, Part 2, Part 3, Part 4. And the directive principles of state policy now come in. Permanent residence come in. Then the state, permanent residence, directive principle of state policy, executive, governor, council of ministers, advocate general, contractor, government of business, composition.
Just 1 minute, this is. Let's go again, speaker's director.
Officers of the state legislature, disqualification of members. It's really a replication of what the Constitution, our Constitution provided. Procedure for financial matters, legislative power, high court, subordinate courts, finance, property, public services, elections, amendment to the Constitution. This is very important. I'll show that to your lordships presently. And then the schedules, speaker, deputy speaker, and all that. Now kindly come us to the preamble. PDF page 16. So, we the people of the state of Jammu and Kashmir. Now, the Constituent Assembly exercise its powers. Drafted the Constitution, adopted. We the people of the state of Jammu and Kashmir, having solemnly resolved in pursuance of the accession of the state to India, which took place on the 26th day of October 1947, to further define, this is important, to further define the existing relationship of the state with the Union of India as an integral part thereof. That's Article 1. And to secure to ourselves justice, social, economic, political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among us all, fraternity, assuring the dignity of the individual and the unity of the nation. In our Constituent Assembly, this 17th day of November 1956, do hereby adopt, enact, and give to ourselves this Constitution. Now kindly see the definition clause. In this Constitution, unless the context otherwise requires, the Constitution of India means the Constitution of India as applicable in relation to the state. Right? Then kindly come to Muller's Article 3, the state. Relationship of the state with the Union of India, the state of Jammu and Kashmir is and shall be an integral part of the Union of India. And Muller's subclause 3 says, just above that, any reference in this constitution to the Sadr-e Riyasat shall, unless the context otherwise required, be construed as reference to the government. This is 1960, which my lord was asking that question. So, Muller's, it shall be an integral part of India. And then 5, Article 5, the executive and legislative power of the state extends to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. Then, Muller's, the issue of permanent residence is dealt with. We're not concerned with that so much. And then you come to 35, page 28, PDF 28. This is an important section, Malaj. Important article. 35. My lords have that. PDF 28. Council of Ministers to aid and advise the governor. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions. All functions of the governor, except those under sections 36, 38, and 92, shall be exercised by him only on the advice of the council of ministers. So other than 36, 38, and 92, Malaj, he will act on the aid and advice of the council of ministers. Now kindly come to 38, 48A, PDF page 33. This was inserted, Malaj, in 1975. Notwithstanding anything contained in this constitution, if upon the completion of a census, but before the final readjustment of territorial constituencies, the Legislative Assembly is dissolved prior to the expiry of its duration, and the governor is satisfied that holding of general elections without delay is necessary, he may, after consulting the Election Commission by notification, direct that the general election shall be held on the basis of the last preceding delimitation of territorial constituency. Then, let's page Article 53, page 37, PDF 37.
Article
53, Malaj, at PDF 37. That's the session of the legislature, prorogation and dissolution. The governor shall from time to time summon each house of the legislature to meet at such time and place as he thinks fit. But 6 months shall not intervene. These are the provisions of the Constitution also. Intervene between its last sitting in one session and the date appointed for its first sitting in the next session. The governor may from time to time prorogue the houses or either house or dissolve the Legislative Assembly. This he can only do it on the aid and advice of the Council of Ministers. It's not an exception because the exceptions are 36, 38, and 92. This is important because it really, the issue will arise. Because Malaj, there was no Council of Ministers when he did this, which is on the 21st of November, 2019. 2018. Well, the importance of this is that he can only dissolve the Legislative Assembly on the aid and advice of the Council of Ministers. The only exceptions that the governor has in the terms of his exercise of power are 36, 38, and 92, which he need not do on the aid and advice. But under 53, he can't do it without the aid and advice, which is what he did. Well, I'll come to that later. Now, Malaj, 92, which is that exception. PDF page 59. This is a very unique power given to the governor of Jammu and Kashmir. Yes. Is concerned, that power to dissolve the assembly would only be exercised on the aid and advice of the Council of Ministers. So when he dissolved the Assembly on the 21st of November 2018, he didn't do it on the aid and advice. And this governor's power has to be exercised in that fashion. The only exceptions are 36, 38, and 92. And I'm now reading 92 for your lordship. This is also a unique provision. Provisions in case of failure of the constitutional machinery in the state. This is PDF, Mullards, 59. My lords have that. Does this call, Mullards? Does your lordship have one?
Page 50?
59, PDF 59, Article 92. My lord have it.
Breakdown of
Yes. Now, provisions in case of failure of the constitutional machinery. If at any time the governor is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this constitution, the governor may by proclamation, Mullards, assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by any body or authority of the state, make such incidental and consequential provisions as appear to the governor to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this constitution relating to anybody, provided that nothing in this section shall authorize the governor to assume to himself any of the powers vested in or exercisable by the High Court. We are not concerned with that. But this he can exercise without the Council of Ministers, unlike in the Constitution of India. Why? Because Jammu and Kashmir has a unique status in the context of its relationship to the government of India. Yes. Huh? And clause 3 of this is important, that any such proclamation, whether varied under subsection 2 or not, shall, except where it is a proclamation revoking a previous proclamation, cease to operate on the expiration of 6 months from the date on which it was first issued. So, whereas the proclamation was issued on November 21st, 2018, on 20th of June, it was to expire in 6 months' time, on 19th December, and whereas he, on November 21st, he dissolved the Assembly. And without reference to the Council of Ministers. But anyway, we'll come to that a little later. Now, most important, is in the context of what we've been arguing all of yesterday and today, is 147, PDF 85, sorry. No, sorry.
Amendment to the Constitution.
Yes. An amendment of this Constitution shall be initiated only by the introduction of a bill for the purpose in the Legislative Assembly, and when the bill is passed in each House by a majority of not less than 2/3 of the total membership of that House, it shall be presented to the Governor for his assent, and upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. Provided that a bill providing for the abolition of the Legislative Council may be introduced in the Legislative Council and passed by it by a majority of the total membership of the Assembly and by a majority of not less than 2/3 of the members of the Assembly present and voting. Provided further that no bill or amendment, now this is important, provided further that no bill or amendment seeking to make any change in this section or the provisions of sections 3 and 5 or the provisions of the Constitution of India as applicable in relation to the state shall be introduced or moved in either house of the legislature. So, Maharaj, you cannot amend as it is made applicable to the constitutional order made applicable to the state of Jammu and Kashmir. So no legislature can even move a bill. This is what makes it permanent. This is exactly why it is permanent. It had to be temporary because at that time there was no constituent assembly. It was temporary, it had to be temporary. Per force it was temporary. Even 3 cannot be amended. Section 3 cannot be amended.
But can the permanency of Article 370 be a consequence which follows from the Constitution of Jammu and Kashmir?
No, it's made applicable to Jammu and Kashmir by an application order.
No, but you're saying that this provision,
Yes.
Article 147 of the J&K Constitution,
Yes.
makes Article 370 permanent. Can the permanency of the Indian
Yes,
Constitution...
because, brothers, kindly see, the 370 was made applicable to the state of Jammu and Kashmir by an application order. 373, brothers, kindly. Subclause 3 gives powers to the Constituent Assembly, no?
Those powers clearly
Those-
doesn't have.
That legislature doesn't have those powers. Country middle what happens is when you impose Article 356, you talk over the powers of the legislature. Under which power did they exercise that right?
Not of the legislative assembly.
Yes, exactly. That's what I'm saying, Malad.
Mr. Sabal,
But then how is proviso C will applicable?
Yeah.
how can you are saying Article 147 gives the permanency to Article 370?
Because the Constituent Assembly, I'm sorry, I shouldn't interrupt you, Lord.
Now, can the Constitution of J&K give a permanency to Article 370 of the Constitution of India?
Exactly. But that's all we are saying is that the Legislative Assembly does not have the power under 370 subclause 3. That's all that I'm saying, nothing more than that.
What you are saying is Legislative Assembly cannot exercise the power under the proviso to clause C,
yes,
clause 3
yes.
of Article
So what,
370.
then
That's
what,
not-
that's what, why they did, they converted the Legislative Assembly into the Constituent Assembly. That's what they did, Malad. This is what is shocking.
The lighter side, the Parliament did it.
I'm sorry?
On the lighter side, the Parliament did it.
Yes. So Parliament converted itself into the Constituent Assembly of the state. I mean, it's unheard of. Yes, no means but we'll show it. We'll show it. We'll demonstrate that. At the moment, all I'm saying is, Malas, you cannot exercise, the legislature cannot exercise powers to amend 373. Yes, even some other body takes over those powers, that only powers can be exercised is the powers of the legislature, nothing more than that. That's the whole scheme of 356 is if you take over.
The Parliament can do it or not.
Yeah, well, Parliament exercises the powers of the legislature under 356. It can't exercise any other power. And that's the scheme of 356, which I'll come to later. That's Bomai, mothers. Now that's settled. You can't arrogate to yourself a power that the legislature doesn't have. That's why there's an interplay between the Constitution of India, the Constitution orders applicable to the state of Jammu and Kashmir, and the Constitution of Jammu and Kashmir and 370 itself.
That's what you flagged in the beginning when you
Yes,
began your speech.
That's the issue.
Actually, Article 147, the second proviso to Section 147 of the J&K Constitution, would seem to indicate that the provisions of the J&K Constitution are treated to be subordinate to the Indian Constitution. Which is why no amendment in the relationship of the Indian Constitution and its application to the state can be introduced in the state legislature. The state legislature cannot change that relationship.
Correct, but I'm not disputing that. It is the legislature cannot introduce a bill to that effect. And what's the procedure? Only under 370. It's only under 370, Manoj.
But this is in that sense a subordinate instrument in its application to the
Well, it's-
relationship
it's a
to the
subordinate-
Constitution of India.
But Manoj, kindly see, one second, kindly see, just 1 minute. Kindly see the Constituent Assembly has now framed the Constitution. The Constituent Assembly has not exercised the power that it had, Manoj, to abrogate 370. In that process, the Constituent Assembly, when drafting the Constitution, decided that nobody can change that status. The legislature cannot change that status. Now, whether Parliament on its own can change that status is a separate issue, but the legislature cannot change that status. That's the element of permanency as far as the legislature is concerned. Let me put it that way.
The legislature has no authority to change the relationship between.
That's correct.
That's what
Legislature
you're
cannot
saying.
change. Why? Because this is not a temporary provision. Come to that. That's clear, Manoj.